Criminal cases in the Magistrates Court and Crown Court. Criminal courts deal with all cases where a crime has been committed and there is enough evidence gathered against the alleged offender for there to be a reasonable chance of conviction. Civil courts deal with disputes between private individuals and/or organizations, such as the non-repayment of a debt, personal injury, the breach of a contract concerning goods or property, housing disputes, bankruptcy or insolvency. And finally, family courts take care of the disputes relating to family matters, including divorces, disputes about financial issues or custody of the children following the breakup of a relationship, domestic violence, adoption, protection of children from abuse or neglect. So let's begin by looking at criminal cases. All criminal court cases start in a magistrate's court, and the vast majority will finish there. The small number will be referred to a higher court, usually the Crown Court. There are some offences such as motoring offences or disorderly behaviour that are dealt with only by magistrate's court. These offences are known as summary offences. The maximum punishment for a single summary offence is 6 months in prison and/or a fine of up to £5,000. An interesting fact is that about 1.5 million to 2 million criminal cases go through the magistrate's court each year. Magistrates deal with 3 kinds of cases. Summary offences, these are less serious cases as mentioned previously, such as motoring offences and minor assaults, where the defendant is not usually entitled to a trial by jury. They generally end in the magistrate's court. The next category of offence that the magistrates deal with is either way offences. These can be dealt with either by magistrates or before a judge and a jury at the Crown Court. That's why they are called either way offences. So what are some examples of these either way offences? Examples include theft and handling stolen goods. In such a case, a defendant can invoke their right to trial in the Crown Court. Now, magistrates can also decide that a case is so serious that it should be dealt with in the Crown Court. The reason serious cases are dealt within the Crown Court is that they can impose tougher sentences if the defendant is found guilty, whereas the Magistrates' Court do not have that ability. The magistrates can impose a sentence, generally of up to 6 months imprisonment for a single offence, 12 months in total, or a fine generally up to £5,000. And then thirdly, there are indictable only offences such as murder, manslaughter, rape and robbery. These must be heard at a Crown Court. If such a case is brought to the Magistrates' Court will generally decide whether to grant bail, consider other legal issues such as reporting restrictions, and then pass the case on to the Crown Court. If the case is to be dealt within the Magistrates' Court, the defendants are asked to enter a plea. If they plead guilty or are later found to be guilty, the magistrates can impose a sentence or a fine as mentioned previously. If the defendant is found not guilty, they are acquitted as the defendants are judged innocent in the eyes of the law. Cases are either heard by 2 or 3 magistrates or by 1 district judge. We just discussed the most serious offences like murder, robbery or rape can only be dealt within the Crown Court, which is able to hand out more severe sentences. So let's look at the Crown Court more closely. Approximately 100,000 cases per year are passed to the Crown Court to be tried. A further 40,000 cases are also passed to the Crown Court because the punishment the Magistrates' Court thinks the defendant deserves is more than it can give. So it is a very busy court. Offences tried in the Crown Court are divided into 3 classes of seriousness. Class 1 offences are the most serious. They include treason and murder. Class 2 offences include rape. Class 3 includes all other offences such as kidnapping, burglary, grievous bodily harm and robbery. You must be thinking why there is a need to divide the serious crimes into classes. Because they are heard by different visiting judges. The Crown Court is divided into 3 different types of centres depending on the type of work they deal with. These are first tier, second tier and third tier centres. First tier centres are visited by High Court judges for Crown Court criminal and High Court civil work. Second tier centres are visited by High Court judges for Crown Court criminal work only. Third tier centres are not normally visited by High Court judges and handle Crown Court criminal work only. And then there are circuit judges and recorders. Class 1 offences are heard by High Court judges. Class 2 offences are heard by circuit judges under the authority of the presiding judge. Class 3 offences are tried by the circuit judge or a recorder. The Crown Court deals mainly with appeals against conviction and/or sentence in respect of criminal offences dealt in the Magistrate's Court. The Crown Court may dismiss or allow the appeal and vary all or any part of the sentence. Appeals are usually heard by a circuit judge sitting with no more than 4 magistrates, normally 2.